Hello and welcome to Verdictum. This is Kanchan and today I'm going to explain to you a few judgments of this week from the Supreme Court. A two-judge bench comprising of Justice Sanjay Kishan Kaul and Justice A. Amanullah ruled that the objective of Section 14 of the Act, which aims to protect the tenant for 5 years, was fulfilled as the proceedings continued for an extraordinary period of 38 years. They expressed the opinion that such a prolonged passage of time would nullify the initial hindrance against the eviction suit. In this case, the appellant purchased a property in Jaipur which was already rented to the respondent. The appellant filed a suit for eviction before the additional civil judge, which was dismissed for not being in accordance with Section 14 of the Rajasthan Premises Control of Rent and Eviction Act 1950. The Supreme Court, on the interpretation of Section 14(3) of the said Act, said that in order to analyze the expression used in Section 14(3) of the said Act, we think it is appropriate to consider the objective of this provision. This provision is for the protection of the tenant. The objective is that from the date a tenant is acquired a right, he must have the right to continue in the premises for a period of 5 years, subject to his fulfillment of the terms and conditions of the lease. While allowing the appeal, the Apex Court, considering the case, stated that whether the term used is shall lie or be entertained, it does not matter. The main aim is to create a barrier for the specified period under the Act. The court also emphasized its extraordinary powers under Article 142 of the Constitution of India to ensure absolute justice between the parties. Thus, the eviction decree passed by the First Appellate Court on 18/3/2004 should be upheld, requiring the respondent to vacate the tenanted premises by 30/9/2023. The respondent is also asked to submit an undertaking to avail of the benefit for further occupation until 30/9/2023 within 2 weeks. The three-judge bench comprising Justice B.R. Gavai, Justice Vikram Nath and Justice Sanjay Karol observed that the amendments to the CVC Act, DSPE Act and Fundamental Rules 1922 are constitutional. Thus, the challenge to the validity of the respective Amendment Act failed and the writ petitions are rejected. Writ petitions were filed by Common Cause versus Union of India seeking to quash the centre's order for extending the respondent's tenure. The petitioners challenged the validity of the Central Vigilance Commission Act 2021, the Delhi Special Police Establishment Act 2021 and the Fundamental Rules 2021. The respondent, previously serving as Principal Special Director in the Directorate of Enforcement, had been appointed as Director of Enforcement for a 2-year term from November 19, 2018 or until further order, whichever was earlier. The amendment extends the power of granting extensions to the Director of CBI and Director of Enforcement, similar to the other certain officers under central government, based on public interest. However, this extension is limited to a maximum of 2 years or the period specified in the relevant act or rules governing their appointments. The court, while addressing one of the issues, cited a prior ruling by a constitution bench of 7 judges stating that a subsequent enactment cannot nullify the writ of mandamus issued by the Calcutta High Court, which settled the rights and liabilities between the parties. It clarified that legislative acts can render the effect of court's judgment void even retrospectively if they remove the basis on which the judgment was founded and rectify the identified defects. The court firmly stated that nullification of mandamus through an enactment is an impermissible exercise by the legislature. Such action would breach constitutional boundaries and encroach upon judicial power, violating the principle of separation of power or rule of law and Article 14 of the Constitution. The court also dismissed the argument that the judgment in the case of Common Cause 2021 was undermined, as there was no prohibition on the government to appoint a Director of Enforcement beyond 2 years. The court acknowledged that the centre should not have issued orders contradicting the mandamus from its judgment in Common Cause 2021. Despite finding the extensions to the respondent number 2 as invalid, the court considered the concerns regarding FATF review and the time-consuming appointment process for the Director of Enforcement. Thus, in larger public interest, the court allowed respondent number 2 to remain in office until July 31, 2023 as a smooth transition measure. The apex court granted partial relief to the pleas in this regard. The two-judge bench of Justice B.V. Nagaratna and Justice Prashant Kumar Mishra observed, insofar as the claim petition filed by the appellant herein is concerned, alleged negligence on the part of the driver of the tanker lorry and the pickup van in causing the accident has been proved. That is a matter which has been considered on the basis of preponderance of the possibilities and not on the basis of proof beyond reasonable doubt. The petitioner's son was involved in a collision with the lorry, resulting in his and his friend's death. An FIR was lodged against the petitioner's son under Section 279 and 304A of the IPC. The petitioner sought compensation through a claim petition, but the Assistant Commissioner of Police filed the FIR accusing that the petitioner's son of abetting the accident. Although the final report termed it as an unavoidable accident and cleared the son of negligence, the High Court quashed the report. The court found that the High Court's approach to assess the final report's findings as incorrect and improper, leading to its quashing. The High Court's opinion, stating that the incident was attributable to the petitioner's son's rash and negligent driving, was considered inappropriate as it exceeded the scope of reviewing the final report. Therefore, the court set aside the High Court's order solely based on this reason. Furthermore, the court emphasized that the final report's finding had no relevance to the claim petition. The petitioner sought compensation for his son's death, attributing the accident to the negligence of the tanker lorry driver, not his son's action. As the result, the court allowed the appeal and overturned the High Court's challenged order. The two-judge bench comprising of Justice Abhay S. Oka and Justice Rajesh Bindal held there is a huge delay on the part of the respondents to avail of their appropriate remedy against the final publication of record of right. Hence, the respondents are not entitled to any relief. On the application of principle of constructive res judicata, the writ petition filed by the respondent after withdrawal of the civil suit was not maintainable as no liberty was granted. In this case, still finding the writ petition was to be justified, at least complete facts need to be disclosed for the purpose which were missing. The Odisha High Court's order was contested through an appeal in this case. The respondents representing the deceased Lakshmi Narayan Das had filed a writ petition after 18 years, alleging that their objections during the settlement process were not addressed, resulting in the land being recorded under the GAD. Despite filing a representation, it remained unresolved, leading to the dismissal of the writ petition in the jurisdiction of interference. An intra-court appeal was then submitted by the respondent, seeking the High Court's consideration for allocating them a suitable plot in exchange for their city-Hibin land. The state challenged this order before the apex court. While dealing with the first issue, the court noted it is evident that there is a huge delay on the part of the respondents to avail of their appropriate remedy. Record of rights were finalized in the year 1962. As admitted in the writ petition, objections were filed by the respondent or their predecessors in interest before that. Remedy after publication of the final record of rights was revised under Section 15B of the 1958 Act to be filed within 1 year. No remedy was availed of nearly 3 decades after finalization of the records of rights. Application was filed before settlement officer, which was not maintainable after final records of rights were published. The court observed that the respondents remained silent for 13 years after the settlement officer's decision and later filed a civil suit, which was eventually withdrawn in 2007. The writ petition was filed in 2008 after 46 years since the finalization of the record of rights, making it highly belated. On considering the second issue, the court found out that the respondent had waived their right to challenge the record of rights, as no challenge was made for decades. Moreover, no official order for land allotment was issued to the respondent. Therefore, they were not entitled to any relief solely based on official notings. The apex court allowed the appeal and set aside the High Court order accordingly. Thank you and keep watching Verdictum, the dictum of truth. Subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with the latest legal developments.